For starters, I'll indicate there was a protective order issued in this case, and it was filed under seal, and that was issued on July 15th, 2021. Courts reviewed the contents of that order, and pursuant to Idaho Court Administrative Rule 32I, the court does find that for purposes of this hearing, counsel may refer to and mention the order or the contents of that order, even though it's under seal. The court will make a determination that won't violate the terms of the order sealing the protective order, as it's the subject of today's proceeding. If we need to go into any of the specific details or allegations that led to the issuance of a protective order, the court would ask that that be done in camera, on the record, but outside of the public view and a closed portion of the proceedings if necessary. Appearing today for the state is Lindsay Blake, who will be arguing the motion. On behalf of the defendant is Mr. Archibald, and I understand, Mr. Archibald, your client is listening in telephonically to this hearing. Is that correct?
Yes, Your Honor.
Okay, thank you. We are conducting this hearing by Zoom remotely. It's also being live streamed on the court's YouTube channel for public access to the hearing. And so I will bring up another part of this motion. It was filed on shortened notice on December 29th, and so we're having a hearing on shortened time frame. I wanted to ask Mr. Archibald if you object to the proceedings going forward today on shortened time as requested by the state.
Your Honor, when they asked if I would be okay with setting this in within the time frame, I said yes, that's okay to set it quickly. I still do intend to object to the contents of the motion, but I'm okay with proceeding.
Very well then. On the motion for request to shorten time, the court will grant that, and we will proceed forward with the substance of the hearing then today. So the state's filed the motion, the court's reviewed that. I understand Mr. Archibald has an objection to the motion, so Ms. Blake, if you'd like to offer argument in support of your motion, you may.
Thank you, Your Honor. The state did file a motion to clarify, or in the alternative, to extend the court's protective order, which was put in place pursuant to Idaho Rules of Criminal Procedure, Rule 16 specifically, and specifically subsection L. The state had previously filed a request or a motion for a protective order to be put in place with regard to the discovery in this case. There was later a hearing regarding that motion with regard to the case number applicable to Chad Daybell. That order was essentially modified with regard to that case number. However, it's the state's understanding that the order, that protective order, remained in place specifically with regard to Mr. Means in Ms. Vallow's case. That motion was supported by a sealed declaration or affidavit under Idaho Criminal Rule 16L, or Rules of Criminal Procedure 16L. The requirement is that that declaration remains sealed if the protective order is granted. So the state did not intend to get into the details of that declaration today, specifically because it is sealed and has not been provided publicly or to counsel at this point. It's the state's understanding that this court had reviewed that in making the determination to keep the protective order in place with regard to Mr. Means. It's the state's position that this court has broad discretion when determining issues with regard to discovery and whether or not there should be a protective order in place to protect the integrity and the fairness of all parties, or the right of all parties to a fair trial. The state's position is that that authority of the court over the discovery, the protective order, and or potential dissemination of those discovery materials remains within the court's purview and control, whether or not counsel is active in the case. So the state had initially, this is a two-part motion the way it's drafted, because it would be the state's position that that protective order actually is still in place, and we simply wanted to clarify that. and specifically with the additional hearings that happened with regard to the protective order, it's specifically in place with regard to Mr. Means. The state's position is it does not matter whether or not he remains counsel of record, that the court maintains discretion and control over that protective order, and we would just ask to have that clarified. If in the alternative, the court does not view that as currently being in place, then we would be asking the court to consider expanding or extending that order, continuing forward. In addition to that, the state would note, and the court is probably aware, there have been certain discovery materials that have been disseminated or disclosed that relate to this matter. They were not disclosed specifically here in Idaho, but have been disclosed in other jurisdictions or in another jurisdiction. However, it is still the state's position that given the voluminous amount of discovery in this case, there is still a significant amount of discovery materials that have not been disclosed or disseminated to the public, and that it would not be in the interests of any party's right to a fair trial if those were to be disclosed. Specifically, there are some very sensitive documents that have not been disclosed. Again, based on the protective order being in place, the state did not intend to specifically list any documents. If the court felt that it was necessary or important for the court to know what some of those documents are, I think the state would request to discuss that in chambers and then make a determination whether or not the court wants that placed on the record. But that would be the state's position with regard to that. I think in addition to that, Mr. Means has an ongoing obligation based on the court's recent order with regard to removal of Mr. Means from this case. There was a finding that he had represented both Chad Daybell and Lori Vallow Daybell. So it's the state's position that he has an ongoing ethical obligation as well to both of his former clients under Rule 1.9. And we think the court can take that into account as well in determining the appropriateness of continuing forward with this protective order to ensure the integrity of this case and the rights of everyone to a fair trial. In addition to that, with the court's most recent order and some of the issues or concerns that were addressed in that order, and the state recognizes some of the state shared in those same concerns and had raised a lot of them in response to some motions filed by Mr. Means. But specifically what the state is referencing or looking at is the concern regarding Mr. Means filing documents under penalty of perjury and documents that specifically referenced or at least alluded to conversations he may have had or did have with his client, Ms. Vallow Daybell. The state has concerns, shares the court's concerns regarding those and the potential for Mr. Means to become a witness in the case. So we would ask the court to consider looking at Rule 1.9, and the court had previously referenced 1.7 in the court's prior order, whether or not some kind of an additional order prohibiting or restricting disclosure of any conversations he may have had with Ms. Vallow Daybell and or discussion of the most recent pleadings that have been filed where that was referenced. The state believes it may be prudent for the court to look at entering some kind of an additional order. We wanted to raise that concern and leave it in the discretion of the court. The state does not believe anything has changed with regard to the protective order and the need for the protective order or the potential negative ramifications and implications if that order is lifted with regard to Mr. Means.
Let me ask a question here, Ms. Blake. The protective order, in effect, relates specifically to documents in discovery and information in the case. I guess the concern I have is what's being raised here. To me, seems like you're asking for what I would consider a gag order, where in your motion is requesting that I order that he be prevented from public comment, for example, and as you just mentioned, from essentially talking about the case, which to me, that's a request for a gag order, which is certainly different than the order that's in effect that only relates to discovery in the case. So is the state asking for a gag order here?
We are not, Your Honor, and I guess I should be clear on that, and maybe I'll clarify that a little bit better. We are asking that the court clarify whether or not the current protective order that has been granted specifically is currently in place with regard to Mr. Means that is applicable under Rule 16L. We're asking for clarification that that remain in effect. If the court did not see it as remaining in effect right now, we would be asking to expand or extend that order to continue to remain in place with regard specifically to Mr. Means based on the attached declaration that was filed with the state's motion and the rationale provided in there. And then so that was kind of a two-part argument. And then the third part, and I think I called it a two-part argument, but the third part would be the state just wanted to essentially address our concerns and join in the concerns addressed by this court in the most recent order regarding those communications. We are not specifically asking for a gag order. We wanted to raise the concerns that the state had and then leave it in discretion of the court whether or not any kind of an additional order is appropriate. I think in our motion, we also specifically outlined the state is not asking for a gag order, generally speaking, because we have indicated in our motion, and it would be our position, that we do think if at any point the court ordered or the court authorized Mr. Means to talk about any of the discovery materials under the protective order that was put in place under Rule 16L, and or if the court did create any other kind of an order restricting Mr. Means' comment regarding conversations he's had with his client, that would still be in the court's discretion to allow those comments to occur. The state is not trying to become the micromanager of those. We just had concerns and felt it was more appropriate if the court and or current counsel, Mr. Archibald, if one or both of your permission were required for any kind of disclosure regarding the discovery materials, and then separately if the court does enter any additional order regarding restriction of conversations, that then the authorization be required from the court and or Mr. Archibald for those to be made public or for public comment to be made regarding those matters.
Okay, well, thanks for your clarification on that point. Mr. Archibald, what is your response to the state's request?
Your Honor, I was not involved in the case when the initial protective order was put in place by Judge Watkins in July of 2021. I've seen the order. I don't know the reasons for that. I know there are rules of